another episode of the Senior Podcast Show. I am your host, Corey Lear, the Director of Communications with the Senior Companies. And as always, I am joined by a very special guest. Today, I am joined by our Senior Network partner, Michael. How are you? Welcome to the show.
I am good. Thank you for having me.
We are so glad that you are here because throughout the past couple of episodes, we've been talking a lot about different senior topics, and that's ranging from senior living to socialization, how to get people involved in the holidays if they have mobility issues or other impairments. But I think some things that go not talked about that should be talked about on a regular basis that I think some people are maybe afraid to have the conversation about is one of your main streams, which is estate planning.
Correct.
So Michael is the managing member of Marsalese Law Group in Bloomfield Hills, Michigan. We invited him on today to share his expertise and help us learn a little bit about why estate planning is so important. Can you tell us just a little bit about your background?
Let's see. I've been practicing for about 37 years now, since 1985. Over 33 of those years, I've been doing estate planning. I was a city attorney, assistant city attorney at Warren for a couple of years. And I have done some work in the securities area and doing contract work.
When you first decided, how did you decide what type of law you wanted to practice? Because it sounds like, I mean, that's a long career. It sounds like you maybe tried out a few different things.
Correct. And it's sort of like a funnel. So in the early 90s, I did corporate bankruptcies, and the owners of the companies would have assets, and they ultimately, when their companies went bankrupt, they had personal guarantees, so the bank took all of their assets. So I sat down and we figured out different ways on how to protect business owners, and we utilized revocable living trusts. And so that's kind of how it started.
That's how you were like, oh, I can do this for more than just corporate.
Yes.
Yeah, that's amazing. And I think knowing that you're helping protect people probably gives you those good feelings too.
Yes, it does.
I mean, because I think most people walk in and I don't know if they're like me, this is one of my weakest subjects, so I have a lot to learn. So I think knowing how much you can bring to the table and really, really help protect people.
Yes.
I think that's amazing. Michael is also a member of the National Network of Estate Planning Attorneys, Financial and Estate Planning Council of Metropolitan Detroit. So he's very active in his field. I think he really brings a lot to the table. So I am so happy to be able to have him here. What do you think is the number one thing that someone should know as they begin that estate planning journey? If they're thinking about it, it's nagging at them. I mean, besides just calling you.
They have to have the desire to do it.
Yeah.
Because it takes a little bit of work because you have to marshal all your assets. You at least have to have a list of your assets. So when an estate planning attorney sits down with you, they can determine, what the value of your assets are, who your beneficiaries are, the age of your beneficiaries, and that will determine whether you need a revocable living trust or you just need a last will and testament. And if you just need a last will and testament, then we just make sure that all of your bank accounts in your house all have either beneficiary designations or jointly held. So this way your assets avoid probate.
I mean, that's the thing. I think an estate planning is such a vast term that really I think a lot of us don't even know how far that can be broken down and what is the best plan for us. We just come to you and say, hey, this is what I think I need.
Well, what we do is we give you a 2-page form that asks a lot of questions, which we'll talk about in a little bit. And then I also have a asset inventory that I have the clients fill out. And it works as a checklist down the road. So if we do a trust and we have to change the title of the assets, we have a scorecard per se. And this way we can follow up. And the problem with a lot of lawyers that do wills and trust is they don't follow up and make sure that the individual's assets are actually in the trust. And that's probably the biggest mistake that we see, is that people have trust, but the attorneys had them sign the documents, they leave, everybody feels good, but there's no assets put into the trust. And so we, that's where we differentiate ourselves. We make sure that we hold the client's hand to make sure that all the assets ultimately get transferred. And sometimes it takes months. You have to deal with financial institutions and pension plans and IRAs and retirement accounts. So there's a lot of back and forth.
Yeah, lots of red tape back and forth. Absolutely. So can you please just tell us, what is just the basic estate plan? Like, what is the most important? Like, you want to leave your legacy from whoever and whatever you'd like to leave them. That is so important. So what do they need to do?
Well, let's start off with the definition of an estate plan.
Yes.
So what we utilize as a definition is I want to control my property while I'm alive and well. This way you can give gifts out during your lifetime, but also if you become incapacitated, a proper estate plan will have mechanisms in place for someone to take over either your medical decisions or your business decisions. Mm-hmm. And so not only do you want to control your property, you want to plan for your loved ones. And in the event that you become incapacitated, you plan for that. And then after you die, a proper estate plan allows you to give what assets you have to who you want, when you want it, and how you want it. And when we say when you want it, it's sort of like if you have minor children, we like to stagger the distributions.
Absolutely.
25 years old,
21-year-old does not need $1 million.
Right. And that's a key thing with insurance. And we might bop around a little bit.
Yeah.
Like with insurance policies. Most insurance policies, you have your spouse as the primary beneficiary and your children named as contingent beneficiaries.
Yep.
So in the event that your spouse dies and then you die a year later, the insurance company writes a check to the contingent beneficiaries. And if they're minors, then an estate, a conservatorship, a guardianship has to be opened in a probate court. Someone has to, on an annual basis, file a report of an accounting with the probate court, who goes through it meticulously, making sure that all of income that goes to the minor child and all the expenses, make sure that they go to the minor child. But a trust in place will take care of no guardianship and no conservatorship. And that also goes for older adults. Our trust have incapacity language, which allows individuals, when they become incapacitated, for their loved ones to take over, and they don't need court supervision.
I'll say, and that's really important because that is a hassle. I mean, I believe, from my understanding too, is if someone does become incapacitated or they don't have someone assigned as like a POA, they have to have that checkpoint too. So you might have two, a guardian and a conservator. One's controlling the money, one's making the decisions, but then they have to go back that year and make sure that the money was spent was where it was supposed to be spent.
Correct.
And so,
for the best interest of the child.
Yeah. And so then you're saying if you have that trust, you don't necessarily have to go through that.
Correct.
I think that's huge.
Because what we do is we name the trust as the contingent beneficiary of the insurance policy.
Yeah.
So the insurance company writes a check to the trust, and then through the wording in the trust, it gets distributed to the minor children when they become adults. And the same goes for retirement accounts. But because of the Secure Act that was passed a couple of years ago, and we don't want to get too much into the Secure Act because you could probably or already have had a whole podcast or two on it, but we like to have the trust named as a contingent beneficiary of retirement accounts, again, for minors, and just because it extends the 10-year period that the Secure Act reduced the time to spend down the retirement funds, the trust allows you to stretch it over. So that's why we do it that way.
I'll say that's so important for that generational wealth, and
Yes.
keep, really make sure that, financial decisions. I mean, what do they say about lottery winners? They go broke within.
Yes.
And that's why they get this lump sum. And so stretching it out is super important. And I think making sure that you're working with someone who understands that is incredibly beneficial. Can you walk us through some of the questions that you might ask a new client during that consultation? I know you mentioned that you have an assessment, a group of questions that you ask probably prior to them coming in.
Yes. What normally happens is if we get a referral from a financial advisor, and we have a lot of financial advisors that we do work with, and we work closely with. I like to consider myself and my firm as holistic estate planners, which really means that we not only address the legal issues, but we also have your financial advisor involved in the process. We have your CPA involved in the process, because if all three of us can act together for the individual's best interest, that is a very successful estate plan.
That's a trifecta.
Yeah. So what happens is someone will be referred to my office, or just call up from an advisor or from a former client, and I'll get their email address. I'll talk to them for a couple seconds, and then what I'll do is I email them this 2-page client estate planning information sheet and the asset inventory I previously talked about. And I have the clients fill them out to the best of their ability. And I tell them they're not going to completely fill it out. And then what we do is they email it or fax it back to me. And then we schedule a Zoom conference. And so the questions that they ask, that they're asked in the beginning, are number one, like for a general durable power of attorney. We ask, who will be the person that you want to handle your financial affairs in the event that you cannot or aren't present? And so then they write the person's name down on the piece of paper.
Should they have more than one?
Yes. The very next question is the successor agent, in fact.
Excellent.
And so usually what happens is, in a married couple, each spouse is the first person. And then every estate, every family's different. Sometimes they have grown adult children, and they want them. Sometimes they have minor children, so sometimes they have their parents, or usually a sibling. And we always have successors named in all of our documents, a successor power of attorney, and we'll talk about the other documents, but a successor patient advocate, a successor personal representative if it has to go through probate through the will, and a successor trustee if you have a revocable living trust. So this way, after the death of the first person, the client doesn't have to worry, the first couple weeks after their loved one, and it's usually a spouse, that they don't want to, they have to come in the office and they're upset.
Yeah.
They don't have to do that. And usually what happens is I contact the client after I hear of the death and, talk to them and say, you don't have to do anything. Everything's on autopilot. Just grieve, take your time. We don't have to come into the office because we've already taken care of everything. And that's where like the win comes in, and we're helping the clients out. Then one of the next questions is name the person that you want to handle your medical decisions in the event that you cannot. And again, this generally goes to a spouse. But if the client doesn't have a spouse, we go to brothers or sisters, best friends. And so that's the easy part. The hard part is the successor patient advocate, because a lot of times they want all of their children. And I don't discourage that. But the problem is the problems sometimes lie when there's only an even number of children, because what happens when there's a deadlock? And
That's right.
And so what we do is we also like to base it on the doctor's opinions, and the doctor's opinions carry some weight, but the family, or I should say the patient advocate, honors, and that's the most important part, is we ask the client to make sure whoever they pick is going to honor their wishes.
Yeah.
Not necessarily what their personal belief is, but what the client wants to be done. If they want to be, kept alive on intravenous tubes, and if the patient advocate is against that, they have to agree that they will push their feelings aside.
Yeah,
and sometimes they don't.
Yeah, that's why it's so important to have it in writing what your plan is.
Correct.
Because when everything is written, you can't argue it. That's what the hospital or whatever, if it's patient advocate, that's what they're going to have to follow.
Correct. And then the next question we ask is name the person that you want to handle your probate estate in the event that it has to go through probate. And the reason there are probate estates is sometimes you have assets that are just in an individual names. Like years ago, husband and wife during the war years. After the war, World War II, all the soldiers came home, got married, and they all bought houses. And in the 70s and 80s, the husbands started dying off. The deeds were in the husband and wife's name, and the wife never did anything. And so she dies, and the children have to put the house through probate. So one of the things we do is we make sure if there's a widow or widower, when we sit down with them, to make sure that all of their, and that's part of the asset report, is to make sure that we have someone else's name on deeds, bank accounts, and such, so those assets don't go through probate.
Right.
But even plans that we draw up with revocable living trust, sometimes clients forget about accounts, or they don't even know. They completely forget. They die. Everything is tightly in the trust, going along great, and all of a sudden, someone discovers an old bank account or the unclaimed property. And it's amazing how many people go to the state's website for unclaimed property. And they look up every friend and relatives. It's kind of humorous, but it is good because sometimes we find a client has unclaimed property. We have to go through probate for that. But sometimes it's $20 and it's not worth the whole effort. And that just creates a problem for the state, but it is what it is. So that's why you would need a personal representative. And then the last person that we have is a trustee. And this would be the person that you trust to honor your wishes in your trust. So after you die, they distribute the assets according to the way that you want it. And as we started talking earlier about minors, we don't like a minor to get, an insurance payout at 18, 19, 21, because what they do is they either get a really cool car or they have a really nice wardrobe. And that's kind of not what the parents wanted when they had an life insurance policy. So we have distribution dates, generally the age of 25 or complete college or now trade school. We've stuck in there.
That's good.
The second distribution is like 28, and then like the last one's 30. I always like to do 3 distributions. A lot of clients like 2, and that's okay. The reason is I like to have the child or young adult, they make a mistake with that first distribution. They haven't squandered everything. Right. So we allow for mistakes. And then also our trust is 100 pages long, and it contains incapacity language, which we talked about, but it also has a trust protector, which allows the trustee or the successor trustee to go in and make changes if it requires, because of various legislation, including the Secure Act. And what we also like to do is in the distribution, we like to have it spread out for those reasons. But the trust also gives the trustee or the successor trustee the discretion to raid the trust early for what we call home. And that's for health, medical, education, and other, even though it's misspelled the other way.
Gets them all in there.
Yeah, gets them all in there. And this allows a trustee to, if after the first distribution, one of those items comes up and it's a year before the second distribution, the trustee has the discretion to go in. And a lot of times what happens is the young adult gets married and they want to buy a house. Sure. But the second distribution's a year from now. The trust allows the trustee to rate it early in order so they can have a better down payment, or quite frankly, if the payment is big enough, to buy the house for cash. Yeah. So that's the questionnaire that we ask the client. We also ask them if they've purchased a prepaid funeral, if they want to be cremated, and that's always important because we need it documented early on, and usually it's contained in the will. But we also have a separate sheet of paper that just that says that they want to be cremated, so the family knows in that first couple hours after the person is deceased that they know about it. And what we also do is we like to have the clients sit down with their families during the process and go through and say, here's what we're doing, here's what we're thinking on doing, what's your opinion. And I always I have a sheet of paper, it's just numbered, and it's for gifts. And I ask the clients to ask their children what specific items do they want after the parents die. Do they want grandma's chest? Do they want grandma's grandfather clock? And it's so, I'm going to say 80% of the time what happens is one child wants everything, and another child, it's gross, it's morbid, I don't want to be involved, and they don't choose anything, and then they realize that their siblings have got everything, and they had their opportunity. But that's their choice, and they have to live with it. But it's amazing how many clients come back, couples, and say, our one child wants this and this, and the other one doesn't want anything. And it's just typical. But it's important because the children know the parents are going through preparing their estate plan.
Yeah. And that's what I said at the beginning too. Having those conversations, that is a lot of the reactions you'll get. I don't want to talk about that right now. I don't want to talk about it right now. Well, you know what? There's no better time to talk about it than right now, while everybody's at the right state of mind, able to make some of the decisions that you talked about, so that that you're prepared. I get it. No one wants to have these conversations, but it's worse when the person is not there to help you make them.
Correct.
And so that's sort of where my other question was, that's some of the main reasons for keeping your estate plan updated. You've already talked about certain situations where you want to go back and revisit. If something happens to someone, they pass away and they're supposed to be one of yours, you have that backup person. I mean, you need to keep those things updated, or your assets change, or you've decided to sell off that house sooner and the senior goes to assisted living. Like, what happens with those funds? Keeping that updated and having those continuous conversations are so important, because life does change.
Yes.
In the blink of an eye.
And we like to have our clients come in and review their estate plans once every 5 years.
Okay.
And I like to call it, or if life events occur. Life, someone's born, someone dies, someone becomes incapacitated, or someone becomes alienated from the family. Those are all instances where an estate plan might have to be modified. But we have language in our wills and trusts that talks about afterborn children of the couple or of the individual, that if there's an afterborn child, they participate the same as the named
two that are already
children.
listed.
Yeah. So that's a way to protect that. But we like to have them come in every 5 years to discuss. And sometimes the successor trustee or the successor patient advocate, especially when they have their parents, pass away.
Yeah.
And what we also do is if the successor trustee, successor personal rep, patient advocate, power of attorney passes away, we like the client to contact us. Because we always want that second person. If the first person dies, we're okay.
The second one does too.
Well, if the second one dies first, then now you're hanging in the balance if something should happen to the first person. So we want to make sure we close that hole. So
I'll say that's amazing.
Yeah, and you asked earlier what is an estate plan? What consists of estate plan?
Yeah, because some people might say, well, I have a will or I have a trust, that's good enough.
Right. Well, we have two groupings. We have an estate plan that is just a last will and testament. And basically a last will and testament is a letter to a probate court judge telling the judge that these are my assets and these are who I want it to go to. The problem with the probate process is when it's completed, the assets get transferred to the beneficiaries right away. So if the beneficiaries are minors, now you've got some issues that we talked about earlier.
Yeah.
It's part of the will package is you get the general durable power of attorney, which allows an individual to stand in your shoes while you're living, while you're okay mentally, but you're physically not somewhere. And especially like with what we call snowbirds. They have a house up here in Michigan, and I'm licensed to practice in Florida as well. They go down during the winter months, and then all of a sudden they decide they're going to buy a house down there, sell the house up here. And so what can happen is one of the couple can come up to Michigan with the power of attorney in place, and they can sign their spouse's name to all the closing papers, and the other spouse doesn't have to come up for the closing. Also, the power of attorney is good if there's people who travel a lot and they're out of the country. The person with the power of attorney can sign their name to contracts, can do the banking for them, can sell the house. They can do everything that person can do. That's the power of attorney. The designation of patient advocate is the medical document that you name to have an individual stand in your shoes to make medical decisions on your behalf when you cannot. And again, we like to name a couple of people. A lot of times it's all the children, and we do that. And the client knows, though, if there's a even number of children and there's a deadlock, that means nothing gets done. And so what usually happens is one of the individuals will ultimately change their decision based upon, time in the hospital, change of medical condition, and the change of the doctor's prognosis.
Yeah.
So that kind of moves the needle a lot. After that, we also have what I call a HIPAA release and authorization form, which I call it's on steroids. One part of it allows the individual to so I use this document for my mom. Quite frankly, my mom turns 92 today, so happy birthday, Mom.
Happy birthday to your mom.
And but she'll never hear this or see this. But
that's okay.
So what happens is we have this HIPAA release authorization document. So when she goes to a doctor's appointment and I can't go that day, this document is on file with the doctor. I can call them later in the afternoon, and they can tell me everything.
Yeah.
The second part of that document is it allows individuals to receive medical documents.
That is so important.
And so not only do you get a verbal, you get written, and it's huge, especially if the individual needs advanced care.
Yes.
They can take the medical records, and they're electronic now as well.
Yes.
And they can take it to another doctor or to a specialist and take care of that.
Or how many times do you deal with a family member who is in California? And you got a caregiver in the house taking them to those appointments. You say, what happened? They can't necessarily relay that information. So you get this document signed, and then you're able to pick up the phone, and you're able to get those documents so much easier. It's so important to help you make the decisions that you need to make on behalf of your mother or your father or whomever you're the patient advocate for.
Absolutely correct. And then the last document that we have in our package for a will is that's it. I'm sorry. Then we have the trust package, which has the same group, but it also has a revocable living trust, which designates your, it has a lot of information in it. It's pretty complex, but basically what it does is it names who your beneficiaries are, and it names when they are going to get their distributions. So when we have adult children, they get their distributions right away. But again, I like to tell the clients, let's make 2 distributions.
It doesn't matter how responsible you are. Sometimes it's nice to break it up.
Yeah. And so what we do is a lot of times the adult child will get one half of the distribution upon death,
Okay.
and then the other half a year later. And that works because number one is, remember, a lot of this is, inheritance is basically tax-free except for IRA and retirement accounts because they haven't been taxed yet. But when you receive a gift or an inheritance or life insurance proceeds, those are tax-free. And a part of the trust package contains the will, the durable power of attorney, the patient advocate, and the HIPAA form. What we also offer separately is for business owners a business power of attorney, which is huge because if there's a business owner and he owns 100% of the company and he becomes incapacitated, who has the authority to run the business? Who has the authority to write checks? Who has the authority to withdraw money from the corporate bank account?
That's right.
And so what we do is we sit down with the business owner and say, is your spouse involved in the business? No. Okay. So if you become incapacitated, who do you want to run your business while you're incapacitated? And what occurs is usually there's a number two person there. Or if there's a business owner and they don't own 100% of the company, then we like to name the other or one of the other owners, because the other owners don't want your spouse coming in who doesn't know the business.
Especially if they're not involved.
And all of a sudden they have a 1/2 or 1/3 or 1/4 vote. Things don't go well. And, so the non-participating spouse, can only hurt the business. So that's why we like a power of attorney in place.
Yeah, that's amazing. So the trust, just to clarify for our audience, the will, like you said, that is basically just the letter to the judge that says, these are my assets, these are where I want them to go. However, that can still end up in probate, correct?
Oh, yeah. A will
without a doubt.
A will always ends up in probate.
So the trust will protect them from that.
That's correct.
So it's important to have both. I mean, and that just is...
Well, you have to have both. When you have a trust, you have a pour over will. And that's where the pour over will is for the instance where you find an old account or, some money, or you get an inheritance in and of itself, from your, so if you have a trust and you die, and then like one of your parents dies and you get an inheritance, it goes depending on,
that's a whole nother layer.
Depending on if your parents, if their estate plan named your trust as their beneficiary, but some of them don't, a lot of them don't. So there ends up getting a check written to the individual that has to go through probate. And the will isn't really a letter. We like to call it a letter. It's a 7-8 page legal document that's signed, witnessed, notarized.
Yeah.
And we no longer file them with the county probate offices just because we don't. So.
Do you find that if something does, like the judge will pretty much follow that pretty easily?
Yes.
That's good.
Yeah, and it usually, with ours, if there's a trust, it's simple. The beneficiary is a trust. If there's no trust and it's just a will, it will say, to be my remaining after, real simply is after the payment, upon my death, after the payment of taxes. Of course, taxes are always first, right?
Yeah.
They're always in line. And my final medical expenses and funeral expenses, the balance goes to my children in equal shares. Or if you have gifts that you want to, if you want to just give each of your children $50,000 and then the balance goes to a charity, that's how that would say. And speaking of charities and things, I actually had you have a question on your I guess, what do you call this? Our notes?
Yeah, our outline. Yeah,
okay, our outline. A memorable case. So I had a case where I had a brother and sister. My client was the sister. She was like 50 years old. Her brother was a couple years older. She lived with her mother on a double lot in West Bloomfield. The brother was running a landscaping company out of the property. The mom died. The brother treated his sister like dirt his whole life, and especially afterwards.
Yeah.
And so the brother told his attorney that my sister's living with my mom, she should pay rent. So they sent us a letter, and I said, okay, that's fair. And I wrote a letter back to the attorney saying, okay, what is the, acceptable, residential rate? And then the next paragraph said, oh, by the way, I don't know if your client told you, but he's running his commercial business out of that property. So we're going to ask that he pays a commercial rate for his renting. And that topic just kind of went away.
I bet it did.
But the interesting part of that is because the brother treated his sister like dirt. We created an estate plan for her. She was never married. She never had children. And we gave $3.2 million to 5 dog charities.
Wow.
Yeah. So that was kind of fun, writing checks for $250,000. And everyone was very appreciative.
Oh, I bet.
And then my client died, and her last wish was that I never tell her brother. And about 4 months after she died, the attorney representing the brother called me and asked, and I said, I've been waiting for your call for 3 months. And
It took you this long?
Yeah. And she goes, you know what I'm going to ask? I go, yeah. She goes, so when did your client die? I said, about 4 months ago. And she goes, really? She goes, I got 2 questions. I said, all right. Why didn't anyone contact my client? And I go, because that was my client's last wish to me, that no one contacted him. And I go,
wow.
plus he probably wouldn't have went to the funeral. Anyway.
I'll say if it took him that long to figure out she passed away,
Yeah.
obviously,
And then the second part, which I knew she was going to ask, is what happened with the $3.2 million?
She knew the amount?
Because her client got the other half. I'm sorry.
Oh,
so
I see.
So the mom's estate was worth $6.4 million, and they split 3.2 each.
See. Okay.
And so,
yeah, she's like,
sorry, I wasn't clear on that.
What'd she do with her part of the money?
Yeah. So, I got permission from my client before she died to be able to tell them. So I told her that we gave it to 5 dog charities. She, and the other
Just
attorney.
Dead silence on the end of the phone.
But she's a really good attorney, really nice attorney. We got along great. And she goes,
yeah,
Mike,
well,
it's
their
just
problems aren't yours,
Right. But sometimes your client's problems are yours. But we try to stay away from that.
Yeah.
And so she said, it was funny. I said, if your client would have said he was sorry to his sister, she probably would have gave him the money.
That's crazy.
Right.
Well, that's our pride. And again, that's why I like talking about these things and having these uncomfortable conversations are so important. You don't know what can change someone's mind or what stands out to them.
Yes.
You don't have to talk to them every day, but just a little word might have made the difference of $3 million.
Yes. Yep. Can you imagine? Can you imagine that? It's
No, I mean, it must have been a bad situation if she decided to go for dogs instead of her brother. Just saying.
Yes,
I mean, I love a good dog, but obviously you've been helping clients for so many years, lots of different areas of practice. Can you just please describe a little bit about your practice specifically and how can our clients reach you and how can you help them?
Okay. Well, you can reach me either by phone or email. My phone number is area code 586-915-2184. My email address is mm@marsalese.com. Or you could walk into my office.
Even better. With coffee. No, I'm just kidding. I'm just kidding.
Yes, indeed.
But you obviously give advice on estate planning. Is there any other areas of practice that you would be able to help our clients with?
Yes, I do. I do a lot of contract work, which I mean, I draft purchase agreements for businesses, sale agreements for businesses. I prepare manufacturer rep agreements.
You're doing it all.
I like to do the contract work because it's just a little bit different than the estate planning.
Yeah.
But I like it. Plus
using all your skills.
Yeah, it's easy.
Breaks up some of the other things that
But one point I want to talk about before we get off the estate planning is minor children. So what happens with minor children? As we talked about before we went on the air, if there's a young couple or a couple that has minor children, they absolutely need a last will and testament because they need to put in writing who they want to raise their children. Because if a couple, the example I use is you go on a young married couple has 2 children. Yep. They decide to go on a couple's weekend. They go away. They die in a plane crash. Who's going to raise the children? And a lot of things that I do when I'm sitting down with clients, we're talking about life and death here, and the examples are harsh, but they're real life.
Look at the holiday. I mean, we just had Christmas. You hear about 4 people died on Christmas Eve coming back from their family's house. It's unfortunate, but it happens every single day.
Yes. Or the snowstorms in Buffalo. Right. So when you have minor children, you absolutely unequivocally need at least a last will and testament, which sets forth who you want to be the guardian of your children. Mm-hmm. And a guardian is the person that takes care of your child's body and all of what that has to do with. A conservator is the individual that takes care of the money. Now, a lot of times couples say, well, we want it to be the same person. But we try to talk them out of it because we like to have a check and balance. We like one person to watch over the children, and we like a different person to watch over the purse. That's
an interesting point of view.
It stops, and it doesn't happen often, but when it does, it's really bad. What happens is if the same person is the guardian and conservator and 2 children move into their house, they obviously have to do some work to make the house a little bit more manageable. So we've seen abuses in the past where, they put a little addition on to add a bedroom and the 2 children sleep in that bedroom, but they also, with the children's money, put a 1,000 square foot great room so the children have somewhere to play. That doesn't fly.
Yeah.
All right. And so that's the abuse. So if you have 2 different people, so if the guardian who wants to make their house bigger, they have to go over to the conservator and say, we need to add a bedroom on. Here's the quote. The conservator looks at the quote and says, well, why do you need a great room? Or, why do you need to completely re-landscape the whole backyard? And so that's the check and balance. But a lot of times couples say, I trust my brother, I trust my sister implicitly, I trust my parents, and that's fine. All we want to do is make them aware of abuses, and they choose what to do. The second thing is, with regards to minor children, or even not minor children, how about 18-year-old? This personally happened to me. So my son graduated from high school. He went out east to go to college to play lacrosse. He developed a 102 temperature. Oh my! Drove like only 18 and 19-year-old boys do. Drove 20 minutes to the hospital. Because he was 18 years old, they admitted him and they gave him a spinal tap. And then they called us. Oh. And we got a call from the hospital in Gettysburg, Pennsylvania, that said, your son's here. He had 103 temperature. And by the way, we gave him a spinal tap. I lost my mind. And they said, no. I said, how can you do that without talking to us? Well, your son's 18 years old. Yeah. He's an adult. So immediately we put into place so what we did was my younger son, a year and a half younger, when he graduated, we gave his friends, really the parents, as graduation presents, powers of attorney and patient advocates. So the lesson here is anybody that has college students or college-bound students, or children that are 18 years old, they should have a separate durable power of attorney for their adult child and a separate designation of patient advocate for their adult child. And I guess adult child is a misnomer,
Yeah.
but also a HIPAA release form so the parents can be involved in the young adults' medical decisions.
That's a huge point. Thank you
Yes,
so
it
much
is.
for bringing that up, because you're right. Here you are states away, and you have no control over what's going on. And if your son's incapacitated, like you've mentioned, then they're pretty much winging it.
Yes.
Wow. That is something I haven't even thought about yet.
Or they're asking an 18-year-old,
Yeah.
do you want to do this or do you want to do this? And most children ultimately will call their parents, but it's when they can't.
Right.
Or a decision has to be made, and like they did this at 3:00 in the morning, so it's strange, but that's how we learn.
Okay.
That's how we learn. Yeah, he's
Thank
okay.
goodness.
He's great.
Yeah, good. Okay. Just making sure. But I mean, wow, like you said, those situations arise, and that's how you learn those lessons. And I mean, luckily you're in a position that you were able to sort of help other people. Like you said, your younger son, you're like, everybody gets durable medical power of attorney. I think, I do have 2 young kids, and I've been telling my husband this too. I'm like, you have all these great vacations planned for us, and what happens if we never come back?
As I told you before when we were off the air. So what happens in a situation like that is the young couple dies, they don't have a will, they haven't named a guardian or conservator. And so what happens is each side of the family, a husband and wife, each side of the family, someone ultimately, unless your kids are really brats, someone's going to raise them. And it's either both sets of grandparents or your brother and his sister. And so there's a fight in the family. And so what has to happen is somebody has to file a petition in probate court to become the guardian and the conservator. And unfortunately, it has to do with who has more money. And it's not necessarily the money, it's the opportunities that the money brings. You know, the choice, a judge sits there, and the most important point about a minor child is what's in the best interest of the child. Mm-hmm. So when a judge is sitting there, and I'm not a judge, but I've been involved in the cases, the judge has to choose between sending the kid to a private school or a public school. The judge has to choose between the child living in a nice neighborhood or, a middle class or not so good neighborhood. Yeah. The judge has to choose what extracurriculars the child can do with this family as opposed to that family. Yeah. And so ultimately, and which family can afford a good attorney.
Well, and just because it looks good on paper doesn't mean.
Correct. And that's not what you might want.
That's right.
So if you don't want, your in-laws to raise your children, then you need to do something.
Well, and then too, like, what if you have liquid assets in the bank? Like, what happens to your house? And like, then you're not in control of any of that. Mm-hmm. Yeah, those are the things that will keep you up at night. Or at least I hope this is the type of conversation that you listen to that makes you think about your plan and what you want. I mean, I know you gave us a lot to think about. Just from just from the children point alone, not to mention some of the others you mentioned, like what sort of gifts do you want and where do you want them to go? Different life insurance, and who do you want your beneficiaries to be, and who do you want those successors to be? Like, that's a lot to think about. And if you do have a partner that you need to think about it with, those are conversations that you're probably going to need to have more than one time. And so I really encourage people to call Michael, talk to your family about what it is that you want those final wishes to be and how you want them carried out. I think there's no better time than now to get started on that.
We also want to bring up one more point, just one more idea, is blended families.
Oh my gosh!
And again, we could spend a lot of time on that. But what happens when there's 2 individuals, they're divorced, and they each have children, and they the Brady Bunch. Just look at the Brady Bunch thing, family. So what happens there? It's really difficult going through that because each parent wants to make sure that when they die that their children get taken care of, but they don't want to leave out their new second spouse. So that becomes an issue. Especially the easy answer is a prenuptial agreement, but a lot of people are scared of them, and they shouldn't be, because usually you hear a prenup is older rich guy and a young lady getting married, and they're trying to make sure that the older gentleman's wealth stays with his children and not with the gold digger. Not that all young women that marry older men are gold diggers.
This is a very prevalent stereotype.
Yeah. But we want to make sure, so you have to, that takes extra special planning, because we want to make sure that everybody is taken care of the way they want.
Do those kids go to the dad or the
Well, we're just talking about the splitting of the money as well. So it's that is complicated. And it's complicated and it comes up a lot. But it's important. It's important because if you don't act, and what happens is in a blended family, let's just say when the husband dies, the assets go to the wife. And if there's no estate plan in place, when the wife dies, all of those assets go to her children, because the former husband's children aren't her heirs unless she creates an estate planning document. So that's where we want to be real careful.
Yeah, absolutely. I mean, like I said, so it seems like the more answers we get, the more questions you give us.
Yes.
Which I guess I appreciate, because then you're covering all of those bases and making sure all of those fine details, like we talked about before. He was saying how he has such a fine eye for those details. And I'm like, well, with your job, I mean, that's what you need to have. So that's very fitting. But again, can you just tell our audience one more time your phone number?
Area code 586-915-2184.
Thank you so much for joining us on the Senior Podcast Show. If you have any questions, again, you can reach Michael, or you can contact me at kl@theseniormovers.com or at 586-204-8500. And we'll see you next time on the Senior Podcast Show.